One of the great advantages trust planning provides is the ability of the surviving spouse to maintain access to assets after the death of the first spouse. Unfortunately, this continued access oftentimes results in the surviving spouse failing to do the work that is necessary after the death of the spouse, and most of the time this failure has dire consequences to the surviving beneficiaries. The Internal Revenue Code is now 87 pages long, and in that entire treatise, there is only one gift for taxpayers: the step-up in basis on capital assets upon death. The law states that upon death, this property passing to a beneficiary is revalued for tax purposes, and the new basis for measuring capital gains becomes the fair market value of the assets upon the date of death. It is therefore critical that an inventory of the estate with fair market values be completed. In addition, most trusts require that upon the death of the first spouse, a separate, irrevocable trust be established and funded. At the conclusion of administration, the surviving spouse is left with both an irrevocable trust and a revocable trust. If the surviving spouse decides to amend the trust later, or if assets in the trust grow at different rates, it may be impossible to recreate what should have happened after the death of the first spouse. In my experience, this always leads to a tremendous amount of dissatisfaction and fighting between loved ones. So you see, it is imperative that a trust be properly administered whenever a grantor passes away. If you have any questions or need any assistance with any of these issues, please feel free to contact the attorneys at Kalicki Collier. This is Jamie Kalicki of Kalicki Collier, where our attorneys collaborate and innovate to help you succeed.